And I would tell you that this, excuse me, this rule is radical, it is ridiculous, and it is oppressive. And it applies to all employers, no matter how many employees you have. That's what I meant. No matter how many employees you have, this rule applies. And if 95% of the time, within 56 days, we are able to have an election or not, we're not talking about moving this from an average of 56 days to 50. We're not talking about moving it to 40 or 30 or 20, but to 10. If there's any sense of an ambush as an employer trying to create jobs, help families, this rule stands front and center to that point. Now, I have a short question, but a long narrative, so please bear with me, Ms. Melito, as I ask you this question. You've highlighted, and I think Mr. Carter did a pretty good job of articulating the position at the beginning as you were going through your opening remarks. You were talking about the actual process that an employer goes through to try to comply with something that he's completely unaware of, that she has no clue of the actual process until it is hitting her in the face. You highlighted, Ms. Melito, the profound impact that small businesses have on our economy. There's no question that the backbone of our economy are small businesses. And I am fortunate enough to have been one of those small business owners for about 15 years, the last 15 years before I was given this wonderful opportunity and privilege to serve all Americans in the United States Senate. When I look at this rule and the testimony offered by many of you here today, I am struck with a simple conclusion. The rule is drastically tilts the playing field in favor of unions and chills both the rights of employers and employees. As a small business owner, I never faced an attempt to unionize my workplace, but it is telling for me to imagine what this scenario would have done had I still been in business with one of the couple of businesses I was involved with. I want to make sure that as I walk through the time frame, that this is exactly what y'all are talking about. Y'all means all y'all, which is plural and singular in South Carolina. So make sure we understand that. So the condensed time frame between the filing of a petition and an election to as few as 10 days, with a hearing occurring within 8 days of the petition, would absolutely feel like an ambush. And in other words, while I'm out there trying to secure business, I had an insurance business, a real estate business, I flirted with the janitorial business, but got out of that right before I got started. But I'm out there looking for business opportunities, trying to hire more employees, and at the same time, I'm ambushed with this prospect of getting something together that I'm completely unfamiliar with in 10 days. Is that so far so good?
Very accurate.
So as a small business owner with just a couple of dozen employees, 24 employees, and no in-house legal counsel, which I would imagine is completely consistent with the folks who are members of the NFIB, I would be expected, all within a 10-day window, to do a couple things. Number one, understand what an election petition is. Number two, find a labor attorney with NLRB expertise, and, by the way, one that I actually want to work with, which is, no offense, by the way, it could take a little longer than 3 to 5 days, as you talked about at the beginning. Finding one is one thing. Having one that you can actually work with and gel with the most important asset you will ever have as a small business owner. It's your business. And most business owners go into business not to figure out tax loopholes or how to discriminate against people. You go into business because you have this vision of making a difference, growing a business, being a part of the American tapestry, talking about the American dream. And yet, you're going to do these two things and learn what can and cannot be communicated to your employees and figure out which employees are actually eligible to vote. Then you're going to submit to unions the names of eligible employees, their address, email, cell numbers, work locations, their shifts, employee classifications, and ensure all legal arguments are raised at this point in time, because if you don't raise them now, you can't raise them later. And any mistakes that you make, any single mistakes you make, you're going to be liable for. All in 10 days. Am I wrong at all? So, how does this lead to a fair election for the employees, for the employers, when it comes to making this large of a decision in such a small window.
It's not fair. It's not fair for either side. It's not the way it should be, or the way it was intended.
Mr. Carter, any comments to add to that?
We're running, well, please go ahead and answer the question, then we'll go on to the next senator.
Senator, you did a wonderful job describing the scenario, and the impact of the ambush election regulation not only doesn't help the situation, but it injures employees whom Congress presumes, benefit from hearing all sides of the story so they can decide who's telling them the truth and who isn't. And then they can cast their fate and exercise their right.
Thank you, sir. Thank you all.
Thank you, Senator Scott. Senator Warren.
Thank you.